Court calls the case, Gulfside Lakes versus Brittany Berkey.
This is her. My understanding is that she's in the lobby talking to administration, but she's physically in the building.
She's talking to administration.
Yes, I'm unsure. I heard that from the clerk's office. I asked them to let me know when she was going to be sent down to the courtroom.
All right, so I'll pass that matter. She's coming down to the courtroom.
Okay. We still have Berkey, right?
Pardon?
Ms. Berkey was coming down the hall.
There's a request for an accommodation of what?
Not to be in the courtroom while the live stream is up.
That's what I told her. I don't need an accommodation. She needs to come down or she needs to do whatever. And you need to tell whoever's involving themselves in it to do it. Get her down to the courtroom. I told her what we do. She needs to understand what it is and she can come down here. Tell administration quit butting in. Just get her down here. She's coming down, I think. What?
Said she's not ready to come into the courtroom yet.
Oh. Let me call this witness. This is my day. Mr. Fink, on the Brittany Berkey matter, let me say a number of things for the record. Miss Berkey has come to the court. She has requested an accommodation, one of which, for the most part, this court cannot do and won't. And that is that she wishes that the court close the entirety of the courtroom, inclusive of all spectators. She did not want to appear via Zoom because it was being broadcast. She also did not want other people in the Zoom room. That could not. The court, in an attempt to find an accommodation, said that, and it was improperly stated as a private hearing, but it would be a hearing that may not be broadcast. That's fine, so we could get our matter concluded. We're going to do that, although reluctantly, but then indicated that wasn't sufficient. So at that point, I instructed my staff to tell Ms. Berkey to come down to the courthouse. What has been described to me, I guess, as a disruption has occurred. She is presumably outside the courtroom. I instructed my bailiff to inform her that the courtroom is open, that I would not be removing spectators from the courtroom, and that she would have to make a choice as to whether or not she wanted to enter the courtroom. I think what she indicated is she would come into the courtroom, but did not want anybody else in here. That was her answer. That is unacceptable. The courtrooms belong to the people. People can see what happens in the courtroom. So, given that, it seems to me that my choices are to adjourn the matter or to issue a default if she refuses to come into the courtroom. I won't ask you for your input on that quite yet. I will ask Mr. Allen to step out, tell her once again that I am not closing the courtroom, and that she can make her decision as to whether to come in. Mr. Allen, if you would do that.
When will the rain stop falling? When will I see the sun again, sun again? When will the rain stop falling? When will I see the sun again, sun again? The sun again.
Yep. Okay. Go. Hand me my screen box.
Now go. Free. Rah. All rise. The 14A District Court of County of Washington, State of Michigan is now in session. Now, with the executive Simpson resides.
You may be seated. Court does call the case of Jacob Properties Management versus Justin Reeves.
Good morning, Justin Reeves here.
Counsel, state your appearance.
Jay McCurgy appearing on behalf of the complainant.
All right, thank you. What's the plaintiff's claim in this case?
Your Honor, we have rent in arrears for $1,700, late fees of $1,300.
13.
Correct, Your Honor.
So I have rental arrearage of 1,700, late fees of 1,300.
That's what we have, Your Honor.
Okay, before I say anything to Mr. Reeves, where's the 1,300 coming from?
$50 late fee, 26 days.
Pardon?
$50 late fee for 26 days.
It's $50 a day?
That's what the contract states.
Yeah, that's illegal.
Oh,
Just on first blush. Well, let's just deal with the rent. How about that? Mr. Reeves?
Yes, sir.
How are you intending on paying the rent? I'm talking about the 1,700. I'll deal with the late fees in a minute.
I am saving my money, and I have reached out to Hawk and did a SER application. But I
You
am
did an SER?
working.
When did you do an SER?
Maybe 3 or 4 days ago.
Okay. All right. So you're entitled to a stay because of that, but you got to get the paperwork into us. Can you see your screen? I've got to have that form. I'm going to grant you the stay at this point because you filed for an SER. In the interim, is there any funds that you can pay?
Yeah, I can give them at least 500 today.
500? Okay,
sir.
why don't you do this? Pay 500 to the landlord today. All right. Get that
Okay.
form into us. Try to do that right away, okay?
Yes, sir.
Now, thank you for this being my first case, and let's have to deal with these late fees. But those late fees, counsel, here's what I'm going to do. You need to take a look at the case law. If the contract calls for a $50 late fee without getting into the weeds on it all and the details, a late fee can't be a penalty. That sounds to me on first blush as though it's a penalty. Also, late fees have to be related to the cost of collection, and can't be liquidated damages. So I'll leave that there and let you look at it yourself, or
thank you, Your Honor.
or I'll do it for you at some point. So
We will strike those late fees, Your Honor. I did just see what you were talking about, so we'll adjust
Yeah.
that out.
all right.
And Mr. Reeves,
So I'm sorry.
if Mr. Reeves contacts my office, we can I haven't heard from him, so we can just
So we'll adjourn this out. He's going to get 500 into the landlord today toward the 1,700. How much is your monthly rent, Mr. Reeves?
1,700.
17.
Yes, sir.
All right. So the problem's going to be that as of tomorrow, we're going to click in another 1,700. So we got to try to figure this out. All right.
Yes, sir.
I'll adjourn this to June 14th, 2024, 1 p.m.
Thank you.
All right. Thank you, sir.
thank you, Your Honor.
Thank you. Court does call the case of Group 5 Management versus Olivia Bell.
Good morning, Your Honor. Robert Weiss appearing on behalf of Group 5.
Good morning.
And Ms. Bell,
Yes, Olivia Bell.
hello. Okay. How much is plaintiff claiming is owing? Claims his own.
As of today's date, including the court costs, Your Honor, $959.
And ma'am, what do you have to say about that?
I want to know what the 900 and whatever he said is for.
$227 is court costs and the late fee of $75 and the balance is rent.
Rent.
Rent,
No.
$154.
I do not owe any rent. None.
Well, we're showing a balance owing of $41 from January and $154 from February, March, April, and May.
Your Honor, February
Yes, ma'am.
of this year, I gave them $2,100. I was clear of all of that. Where this money is coming from?
Hold it, Miss Bell. Hold on. When did you say you gave them the 2,100?
February of this year.
Okay,
I have-
Mr. Weiss, hold on. Miss Bell,
Yes.
hold on, just hold on. Mr. Weiss, do you see the $2,100 payment?
Well, Your Honor, we had switched operating systems, so the ledger I have does not show $2,100. I can go back with my client and get a ledger from the old system and see if it's there.
Mhm.
All right, Miss Bell,
Yes,
what's
sir.
your monthly rent?
154 now. It went all the way back down because they
Okay.
were charging me 297.
Okay, but you're at 154 now?
Which is
Yes,
what we're showing, Your Honor, from February, March, April, and May, $154 owing, plus a balance from January of $41.
Right. But she's saying that 2,100 was given, so we got to figure that out.
Okay.
So, Miss Bell, so we're going to click into June. When can you get the 154 in? Because I'm going to adjourn it out for them to take a look to figure out where this other money is.
I just paid my 154 day before yesterday.
Say that again to me.
I just paid 154. No, I paid 159 just day before yesterday.
We're not
And
showing.
that was for your June rent?
My June rent.
Okay, so you paid that, you said day before yesterday, so you paid that on the 29th?
Yes, sir.
All right, let me just note that in the file. So you paid your May rent or your June rent?
I say that again, sir.
You paid your June rent
Yes,
already?
sir.
All right, so here's what I'm gonna do. I'm gonna adjourn this to June 14th, 2024 at 1 p.m. Let them check into that 2,400. And then I'm Mr. Weiss, so that we can do this. I'm gonna need to see a ledger.
Yes, of course.
Thank you.
Have a nice weekend as always.
I will do what I can.
Okay.
Your Honor? Yes, and why
Your
are you
Honor?
interrupting? Why are you interrupting me? Who are you? Okay, that works. Court calls the case of Monica King versus Sarah Goebel.
James, thank you for the
And-
plaintiff.
Donald Goebel and Joshua Goebel.
Your Honor, I'm sorry. I'm here. This is Sarah Goebel.
Sarah? Okay, hello.
Those other people on this eviction actually don't live in my home. They're my husband's family members. I don't even know why they're on my eviction, Your Honor.
Who, Donald and Joshua?
Joshua Goebel and Gladys Doan. Donald Goebel don't live there either, but he's my husband.
Okay, well, I have on the complaint Donald Goebel and Joshua Goebel.
And you should have Gladys Goebel or Doan. But I don't know if you remember, I was here last month and she didn't have any of those people on there. So I don't know why she has them on here this month.
Well, I don't
I don't
know.
understand this woman.
Okay. Well, I don't know, ma'am.
I do.
All I know is I also have Gladys Stone.
Yeah, and they shouldn't be on there. They don't live there.
Okay, for whatever reason they are, and we'll figure that out. But you're here, and how much is owing on this, Mr. Fink?
$4,200 in rent, $229 in costs, for a total of $44.29. Your Honor, there's also been a 1 month notice to quit issued that expires at the end of June.
Got it. All right. So, ma'am, how are you intending on getting this paid?
So, Your Honor, again, I don't owe that much. I don't know where she's coming up with these numbers. I don't owe $800 a month. My rent is not $800 a month. It is $720 a month, and it's paid weekly. I don't know if you remember that from the last time also. And I just didn't start paying, and I didn't pay on April 1st. So since April 1st, I have not paid rent.
You have not paid?
Nope,
rent
because
since
she told,
April?
yep, she told me not to. So since April 1st, I have not paid rent. She will
Who
not
told
take
you
it.
not to?
Miss Monica King. And she did tell you that last time at court. She told you the same thing, that she told me not to pay her the money.
So have you saved the rent?
I have not, but I am working. I did file an SER today, right before court. But again, I don't owe that much money. So,
Your Honor, can we
All
just
right.
set this for a settlement conference
Yes, let's do that.
and reserve escrow?
Yes, escrow's reserved. I'll set this for final settlement conference for June 18th, 2024, 9 a.m. That is in person at the court, ma'am.
okay.
That's a
I'll have
Tuesday.
a lawyer.
That's a Tuesday.
Okay. I'll see you then.
And Your
Thank you.
Honor, of course, if she moves out, this non-payment possession only case will be dismissed.
Right. Okay.
Have a good day.
All right.
Thank
We'll
you,
see
Your
you
Honor.
then. Thank you. Gene Ratliff versus Alexandra Klombach and Randy Edmonds.
I'm here. This is Jean Ratliff.
Okay. Who's here? I've got Ms. Ratliff.
Randy Edmonds.
And Alexandra
Okay. Got it. Okay. And Mr. Fink, I'll be right back with you on
Yes,
your
sir.
case.
Thank you.
All right. This is a termination case. All right, Mr. Ratliff, what's your, explain what's going on.
I have asked since fall for them to vacate the house at 8491 Huron River Drive because I want to reclaim the property.
Okay, let me ask you this. Was there a lease on the premises?
No, there was not.
It was a handshake agreement.
It was a handshake
Oh.
agreement.
Gotcha. Okay. Ms. Kleinbach and Mr. Edmonds, what's your position on this?
She did ask us in the fall, but she said that it was the first of the year that we had to be out. But that was 2 days after we had a baby. We're not trying to keep the place. We just signed a lease a week ago. It's been really hard to find a place to live. I think we looked at like 100
okay.
places.
Gotcha. Okay, so let me ask you this. Are you saying you signed a lease to another place about a week ago?
Yeah, but we can't move in until August, 1st of August,
Whoa.
maybe the middle of July.
I would say that they told you they were moving out in March.
All right. And Ms.
I never
Ratliff?
said that I was moving out in March.
You told me the 1st of March that the house that you
Okay,
wanted to
folks.
rented would be empty. So August is way too late.
Well, Ms. Ratliff,
Yes, sir.
looking through your paperwork, did you send them a notice to quit?
Yes.
Yes. It was written on the 10th. and delivered to them on the 10th.
And they've done damage to the house at the disaster.
We have not done damage to the house, Nikki.
Yeah, I would like to know what damage we've done.
Folks, no, not hearing it right now. I'm dealing with something else.
Yes, sir.
Okay. Ms. Ratliff, there's a problem with your case.
Okay.
There's all I have in my file is a letter asking them to leave.
Yes.
Okay. So, and I'm assuming you didn't send the state form to them advising them that, because I don't have it.
The form was supposed to be delivered from the 14th District Court, and it said received on May 17th.
No, that's the complaint.
Okay.
I'm talking. So the letter that you sent on May 10th, right?
Yeah.
Okay. So a couple of things. You sent a letter to them on May 10th. You have to give them 30 days written notice by statute.
Okay.
Okay. So, and it needs to be on a form that complies with all of the court rules. It has to advise them of certain things that they can do, advise them of their right to an attorney. All of those things are on that form.
Okay, where do I get that
letter?
form?
Pardon?
Where do I get that form?
You have to get it from you can get a copy from either the website, you can go to the state website, or you can come down to any of our courts and they can provide you that form. It's basically a 30-day notice to quit. Okay, so here's the problem with the case that you have right now, is that the form that you sent on the 10th doesn't comply with what's required to be sent to a tenant. That's the first thing.
Okay.
Even if it did, you did not give them enough time on the notice. Okay, because you have to give them 30 days. You muted yourself. Okay. There you are. Okay, you follow me?
Yeah.
So, and without getting into the technicalities, I will if you want me to, but I won't. I'm just going to tell you this is the way that it works. I don't really get what's called subject matter jurisdiction over the case to hear it unless there's a proper notice that's sent.
Okay.
By statute, that's how I get it. If I don't have subject matter jurisdiction, I can't rule on the case. And so since I can't rule on the case by case law, the only option I have is to dismiss the case.
So then I have to go get those forms and file them.
And you have to get the forms, get them served. You basically have to start the proceeding again.
Okay.
But because this was a month-to-month tenancy in effect, you have to give them that month period by statute.
Okay.
Got it?
Got it.
Okay. Mr. Edmonds, Ms. Klumba, do you guys have any questions regarding what I've just said?
You said that she has to give us a month. What, before the proceedings start all over again?
She's got to start the proceedings again because the notice is invalid.
So I have a question. So it says on that we have to give them only a 7-day.
Who is this talking to me? I'm sorry.
I'm Jean's daughter-in-law. So it says, It says in the paperwork on the court website that you can give a 7-day notice if they've have extensive and continuing physical injury to the property. So the property there's the outside of it, there is stuff everywhere. So,
Hold on. Okay, so let me explain a couple of things.
yeah,
First thing is that has to be filed in a particular way.
Okay.
The information is correct and can be a 7-day if those are the circumstances. I don't have any proof of that in what I've got here.
Okay.
That's the first thing.
So what do we have to do for that?
The second thing is I cannot give you legal advice.
No, that's okay.
I know that sounds really messed up, but I can't give you legal advice. I can just tell you why I'm ruling on that, but I can't tell you how you should proceed. And I'd suggest that if you have some concerns about that, you may want to consult a lawyer.
Okay.
It's because we're moving out that the stuff's everywhere. I'm getting rid of stuff. We've been here for 6 years.
Sir, I don't know all of that.
Yes, sir.
I just have paperwork in front of me. You guys can tell me whatever. I just don't know. All I know is I don't have jurisdiction to hear the case. Because the court lacks subject matter jurisdiction, this case is dismissed. Thank you.
Thank you.
Court does call the case of Lee King versus Lakeisha Barnes. Plaintiff is here.
Hi. Hi, Your Honor. This is Linking.
And you don't have
I do not have defendant present.
Lakeisha Barnes. First thing, I can't do anything with your case. I can adjourn it out to my next date, but I don't have any service.
Well, because the person is not showing.
No, I don't have any indication that she was served with the complaint.
She did. She got it. She sent me.
Ma'am, I have nothing in my file that indicates she was served with the complaint. I have no proof of service.
Do you mean what kind of a proof for you to get?
Who served the complaint?
I sent her. She said she accepted through the text. I emailed her.
Okay, but ma'am, I don't have proof that happened. I don't have proof that she was properly served under the statute.
So I'm sorry, I'm not quite sure what kind of proof. Should she respond to you, or how do you get the proof?
You have to file what's called a proof of service. Either you or your process server has to file a proof of service with the court that says when and how she was served. I have nothing.
Oh, really? So I just if she received and responded, and
Ma'am, you can tell me that all day. I don't have it. So what I will do, rather than dismiss the case, I'll adjourn you out to June 14th, 2024, which is my next date at 1 p.m. and give you a chance to correct the proof of service issue.
Okay, thank you. And I would
you.
By person or on the Zoom.
You can be in Zoom if you want.
Okay, thank you so much.
Thank you.
Right, bye.
Court stands in recess. Kirk Glasso versus Artie Dracos.
Good afternoon, Your Honor. Jay McCurgy appearing on behalf of the plaintiff.
Oh, this is Gata. Sorry.
Your name again, ma'am?
Gata Dari.
Yes, and for whatever reason, I skipped your name. But you're also on this case. All right. All right, folks, this is the second hearing. Did we get the money judgment corrected?
I believe so, Your Honor.
Okay. And again, counsel, I apologize for that. It made no sense to me, but yes, we do. We're good. Okay. So where are we now in this case?
Your Honor, last time we met, Miss Dari was stating her case as to why she didn't believe she should be on this money judgment. I'm here with Mr. Glassel, and we have reasons as to why we should. If the other parties are not available, we ask for a
Can take a
default.
default as to them.
Mhm.
Ma'am,
Yes, sir.
you
Yes, Your
never
Honor.
moved in, is that correct?
Correct. So due to personal reasons, I did not move in, family health issues. So I reviewed the document or the rental agreement. It says the lease agreement did not stipulate any notice requirement. And so if I had the intent of vacating, or as far as I know, again, a layperson, I can go as far as what I read. So when I made the decision not to move in, that was due to a personal reason. So I never actually, within 2 weeks of actually signing the lease agreement, I decided to make that decision.
Ma'am, but you signed the rental agreement, correct?
Correct. With the intention of moving in.
Understood.
Mm-hmm.
The very fact that you didn't move in, you're still liable under the agreement.
You're right. As far as I understood regarding what was served to me, it was regarding a holdover, which I wasn't aware of any holdover, what was going on with them. I had to reach out to the real estate agent that found the location for me to understand what was actually going on.
Right,
And-
that's right.
and that was-
A holdover. So, counsel, is
And-
all of the rent owing after the lease? After the lease had expired?
Correct, Your Honor. The lease, oh,
No, the last time they made a payment was February, I believe.
February, Your Honor, was the last payment we have.
And then the lease, I think, expired March 31st. So I'll talk to Sophia. She informed me that everything was up to date in regards to the actual rent. So it was 1 month.
Your Honor, if I may clarify, or if I may add some light as to our position, it would be
Certainly.
the parties were both represented by a realtor. Miss Dari and Mr. and Mrs. Draco's applied together. If my client had thought Miss Dari was not going to move in and be a guarantor, we would have signed a guarantor agreement. It was Miss Dari's income that was used to approve the lease or approve the ability to move in. We were never notified that she wasn't in the location. We were never notified that she moved out, which I guess she says she didn't move in. She corresponded with the landlord as if she was a tenant.
I was coordinating because there was communicate.
Hold on a second. But counsel, does the leasing provision doesn't require her to say anything prior to the termination of that lease?
Require her to say anything as far as her moving in or
Well,
not?
meaning, let's assume that all of the parties just vacated at the end of the lease, March 31st, they just leave. Your client wouldn't have claim for any rent thereafter, because they wouldn't be holding over. The lease terminates of its own accord.
Correct, Your Honor. Yeah, I understand. I'm
All
following.
right. So with Ms. Dari, why doesn't her interest just terminate?
So, our position would be that the lease holds everyone jointly and severally liable, and the lease also addresses the holdover period.
Right, but if there are 3 tenants and one moves out, they're gone. There's no lease. They just leave. You're saying she's liable for the other 2 staying?
Jointly and severally, we believe so.
Oh, I understand what the lease says, but she's gone.
So, Your Honor, what we're trying to prevent, or what this could also be, is, and we don't know because parties were represented by a realtor, and my client never met these parties because of the realtor involvement. But we would not, what would happen if she applied just to approve them to move in and then never moved in? What if she was a straw person using credit or income to prove their viability as tenants and then didn't move in?
Okay, what if she did?
That's why we are trying, if we had known that, we would have used a guarantor agreement rather than having her listed on.
I get that, counsel, that things might have been done differently. But the status, once she signed, is that of a tenant. Whether she moves in or not, let's say she had moved in for a month, and then she said, I gotta go, for whatever her reasons are, I gotta go. But the tenancy is still paid for through the end of the lease. But she's not there. She basically has vacated. She's terminated her interest March 31st. Why is she liable for anything in terms of residency afterwards?
We have her listed on the lease as a resident and we're not notified or we did not know she moved out. I mean, she never said, I never moved in. You would assume that she would have mentioned, I didn't move in at some point, but during the entire tenancy, she was corresponding in the group chat as if she were one of the tenants.
Okay, but now she's gone. Let's assume that she was there even, okay? I know she's not. Let's assume that she was there. Come March 31st, she packs her stuff up, she vacates. Why is she liable for any additional rent? She's turned over possession.
Turned over possession to the other two tenants or to us? Possession was never
she is surrendered because she's left.
She never notified us of a mailing address, or how is the landlord supposed to know that
is she required to do that?
Michigan leases require notification of a forwarding address for purposes of the security.
If there's going to be an issue regarding security deposit, certainly.
Yeah, correct.
That doesn't trigger the forwarding address doesn't trigger anything.
So, Your Honor, the holdover provision of the lease would address holding over, and the jointly and severally liable portion of the lease would also state that the parties were jointly and severally liable for that holdover period. It would continue.
Your Honor, may I make a statement? Again, this is not my forte, as green as possible. This is just me doing my research. So I pulled up, and you can correct me if I'm wrong because I don't know this. It says Michigan law on joint and several liability. Under Michigan law, joint and several liability does not extend beyond the period for which I was contractually obligated. Any actions taken by the other tenants after the lease term ended could not be legally attributed to me. The Dracos family have solely decided without my knowledge or consent and continue to live there past the contracted date. Michigan law supports that the tenant cannot be held liable for actions of other tenants once the lease obligations have been fulfilled.
I don't know what you're reading from, but I don't know what you're reading from, but that's fine. That is indeed my understanding.
That's what I pulled from. Yeah. So again, I don't know. I'm representing myself as very minimal knowledge.
No, I understand. I'm just saying she contracts for a year. She fulfills, however that happened, doesn't really matter. She fulfills her obligations for that year. Contract ends. She's not in the premises, which was what the subject matter of the contract is. There are people that may be in the premises. That's fine. But I don't know how her obligation continues.
If her obligation were to end, Your Honor, she would then still be liable for March rent. So we would ask for the judgment for
March rent may be an issue if it goes through March. If March wasn't paid, certainly.
So for
I don't think in anything, and Ms. Dari, you can correct me if I'm wrong. I don't think in anything she has said she's not doesn't hold some liability for the lease term. What and she believed that it was all paid through the lease term, but if it's not, she's liable for that. I don't have a problem with that. It's the period in time after the lease ends, because at that point, she's no longer occupying the premises. She never did, but certainly after the lease term, she's no longer occupying the premises.
Respectfully, Your Honor, may I ask, what was the total amount? And I can pull up the contract of, because again, I was informed by Sophia that they're up to date on everything. The actual lease agreement for, and I can pull it up right now. She's a realtor that she noted, like when I got served, I communicated with her. I'm like, hey, what's going on? Yeah. So there was what is the deposit? How much was the deposit total?
The security deposit?
Security deposit, which I'm sure it wasn't sent back to them. There's still a hold.
Yep, we have 5,700.
And how much was rent total?
3,800.
3,800. So
hold on a second. Stop.
Okay.
Ready, just stop for a minute. Counsel, you're telling me that there's a $5,700 security deposit, right? There's 3,800 owing in rent.
No, there's the monthly rental payment was 3,800. We have rent owing at
1 month.
No, so there's two different.
We have an alarm going off, so I'm gonna have to stop this proceeding. I'll come back at some point. I'm sure you can hear it probably. Court stands in recess.
Alarm went off.
Kirk Gassel versus Dracos.
Jay McCurgy on behalf of the plaintiffs.
Got it done.
All right. Okay. I'm trying to remember exactly where we were, but I think it was really the March rent, which was the issue.
And then I'd asked how much the security deposit was, and I think he had stated it was like 5,600, and then the actual rent is 30. I don't even recall the actual total amount.
Right. The rent is 38, but that's only for 1 month.
And that was only
well, but hold on. Even if I think you said the security deposit was 57, right?
Correct, John. Yes.
All right. So give me 57 divided by 3, please. They could take the security as that, but that's going to happen at a different point in time. Have the folks vacated the premises to your knowledge, Mr. Kirji?
Yes, Your Honor, they have.
So does your client have possession back?
He does.
Okay. So he would, yes.
The lease states that the security deposit doesn't have to be used for rent and arrears, and he was planning on using the security deposit for the damages, which are extensive.
Where in the lease does it say that?
Page 1, the security deposit.
I say in no cases is there obligated. You know what? I'm gonna tell you what. And I'm just gonna be blunt about it, but I mean, I'll listen to everybody, but it seems to me that this individual, Ms. Dari, that all she wants to do is resolve the account. It's a 1 month. And quite frankly, I don't think she's going to be obligated for anything after that 1 month. And part of, if nothing else, if I were to take the security deposit divided by 3, about $1,900 you have of her funds that could be applied to whatever her rental obligation would be remaining on that lease. The landlord doesn't want to do that. That's fine. I think the best thing to do is, since I don't have to grant a judgment for possession, I might as well set this for a final settlement conference in a trial. Because I think, and I'll be blunt, I mean, I think she's sitting here and that the position of the landlord regarding this tenant is whatever it is. I mean, I just don't think it's, I mean,
Your Honor.
she's not hiding from anything. She seems to be willing to try to resolve it. And I'm not sure that the landlord's feeling that way.
Your Honor, my client.
So I'll resolve it.
If we were willing to take, we may be willing to take the 1 month's rent. But there are other associated fees like an overdue water bill and some HOA fines that did occur before the 31st of March that we would like added to it, but we'll take the 1 month's rent as the court sees for this, against
Just
Ms.
the other
Dari.
stuff.
So we have overdue water, January through March, $610. We have late fees of $300 and HOA fine.
Late fees of $300 for how much? How many months?
It's 6 times. So, and 2 have been paid, so 4 times. The late fee is $150.
Okay.
I was unaware, Judge. I was unaware of any of this.
Hold on, ma'am. I hear you. I'll hear you, but so there's an additional what? 1,200?
So we have 610 in 600, and then we have a that's correct, 1,200. 525 in HOA fines. So
5 and
25 in the HOA fines.
What were those fines for?
There were about 24 HOA violations. I believe it was 24. Various things from leaving the dog leash and the cigarette containers out, trash in the lawn, not cutting the grass, leaving trash bins outside of the garage.
Tell you what,
an assortment.
you guys know how to get in touch with each other. I'm just gonna set this for trial. Everybody come with what they have, and then I'm just gonna make a call on it. I mean, I mean, like I said, I'll just be blunt. Miss Dari is here. If you're gonna nickel and dimer, we'll just do it in a trial. And then I can make the decision.
Your Honor, we're not nickel and diming anyone. We're trying to uphold the.
I think you are. I'll be honest with you, counsel. I think when you start talking about HOA, why weren't they collected during the term of the lease from the tenants? Why wasn't there a filing before now?
So, Your Honor, the filing came, there was a negotiation for them to leave. There was an agreement that they would be leaving month, and then they asked for another month. And then finally, when we said we were filing, they vacated the property. So this was an extended period of time where we were expecting the property back.
Okay, but when you weren't, were you dealing with Miss Dari?
I included her on all of the emails.
Which I have.
Dealing with? But who were you dealing with?
Well,
so Your Honor, even the tenants themselves most of the responses were from their son, Nick Dracos, who may or may not have been living at the property. I'm not sure.
Non-jury trial, June 18th, 2024, 9 a.m. in person. Bring all your exhibits, bring all your documents, and then I'll just make a call on this. Miss Dari, you wanted to say something. I'm sorry, ma'am.
No, Your Honor, I don't have anything to really bring other than I'm the one that showed up despite I haven't lived there. The other tenants.
I know, and I just need you to show up at the trial.
Okay.
And then I'll deal with it from there.
And Your Honor, may we submit a default judgment for the other 2 tenants?
I'm setting the whole thing for trial. I'm not parsing them out. You won't parse them out. I'm not going to parse them out. Everybody be here on the 18th in person.
June 18th. What time?
18th, June 18th. I'll be in courtroom A. I'll have bells on. Everybody else have theirs.
What time, sir?
9 a.m.
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
New Park Ridge Apartments versus Ebony Hobbs and Casey Hobbs.
And for plaintiff,
Well, there you are. Hello, what's your name?
Ebony Hobbs.
All right. And where are we on this? There was the hot water, the mailbox key.
I fixed the hot water.
Pardon?
Hot water is fixed.
Okay.
No mailbox key though.
You still don't have a mailbox.
They
key.
haven't reached out to me as well. I reached out to them, got no response. So I paid the $1,028 again.
1,028. Okay. You paid that directly to that.
I paid that on
To the landlord.
Yeah.
On the
Straight to them.
24th. Is that correct? Okay, so what's our balance at this point?
$2,654.
$2,654, and then I have June clicking in tomorrow. So
I haven't said anything.
what's your monthly rent for?
1,028.
That's right. That's how we set that number. Okay, so this will keep us at the 20. We came down, but when could the June rent be paid? Do you know?
I don't know. I've been paying them almost every week. I can't afford to keep paying 1,028 twice a month.
No, okay, I got you. But so tell me what you can do. Because here's what I'm gonna do likely, because you got to get a mailbox key. I'm gonna put it out to the 14th. Okay.
Okay.
So what I guess I really was asking, between now and the 14th, what can be paid? Let's do it that way.
I can pay 500
500.
until I get paid on the 7th.
So 500 on the 7th.
Mhm.
Okay, so I'll put 500 on the 7th. That'll work. I mean,
I could pay the whole thing, but I'm just refusing to at this point. They're not willing to reach out.
Why?
I'm
You know
just-
what? She could have just let it slide.
I know I can't.
And I would have just let it just go. Like, all she's got is
This is-
500. Well, no, I could pay the whole thing, but
But I'm not. But I've reached out to them several times about just, if you get the late fees off, I'd pay it in one
All right,
month.
listen, just listen.
They don't want to. Sorry.
No, I'm just gonna let you talk.
Thank you.
You ain't gonna let me.
Plus, I walked here.
You walked here?
I walked here. So,
Okay, so here's the deal.
okay.
Get the 500 in. Can you? Is 1,000. Let me ask you, can you do 528?
I can even go, yeah.
Okay, I want to keep the numbers where I can. Okay, so pay the 528, so it's I get your point. I mean, I make fun of it, but I get your point.
Yeah.
Okay. And so then I will adjourn this out to the 14th. Can we get our mailbox key?
Yes, Your Honor. Yes. And then Ms. Hobbs, you're contesting late fees or asking for a waiver of late fees. What amount of late fees? Like what amount?
They weren't, she just told me the late fees were out of the question to waive. So I haven't heard from her since then. So I'm just trying to figure out a fair amount where I can,
She said to you what?
that she wasn't waiving, they don't waive late fees, just go to court, is what she told me. And
So I have to.
absolutely, on the court.
So, but with that being said, what amount are you asking for? Do you have an amount that you're asking for?
Not really, because I just got the ledger. Like
You
yesterday.
just, correct me if I'm wrong.
Okay,
She is looking, really what she's saying, at least what I'm understanding is, I ask you to do certain things, you guys really aren't doing it, you're not paying attention to me. The only way I can get your attention is not paying. And so then when I finally get your attention, you want me to do that plus the late fees. So whatever late fees accumulated during that period, I'm trying to get your attention, I don't think I should pay, because all I'm really trying to do is get your attention. Is that just another way of saying it?
oh, great.
Yeah.
You go viral for this moment too. Perfect moment. Perfect.
Yeah, I'm just gonna be known as like the Ebony Hobbs Whisperer.
I swear.
All right, so that, and thank you for saying that, I guess, ma'am. All right, so with that in mind, I think council can look at it maybe talk to Ms. Hobbs at some point in between and see if some resolution regarding that can come up. And then maybe we can just get this resolved so that Ms. Hobbs,
That's all I
Ms.
wanted.
Hobbs doesn't have to walk up here
I do.
and let me know that she walked uphill both ways.
I did.
All right.
Our phone number, our office phone number is on paperwork that you received under James Fink.
Okay.
If you want to call that, once you look at the ledger, if you want to call that, make any sort of offer, then I can present it to my client and I'll communicate with them about the mailbox issue.
That's fine.
Thank you.
Okay, June 14th, 2024 at
3 p.m.
3 p.m. Okay,
Awesome. Thank you.
all right. Have a nice walk back. I got, and I gotta say, you're better than me, because I would have stopped halfway and just said, I ain't. Not realizing that if I walked halfway back, I would have been here, but anyway.
My job is less than 5 miles away, so not bad.
5 miles?
I'm right off Hacker, so it's not that far.
5 miles.
Yeah. This is nothing.
5 miles, walking 5 miles.
It's nothing.
Okay.
Have a good one.
You know what?
Gotta wrap up.
If I had a job 5 miles away that I had to walk to, you know what they'd call me? Unemployed. Hermara versus Cold Scoops. DBA Bigsby Coffee. Somebody on here, Cold Scoops is here. Somebody on from Cold Scoops, you need to answer.
Oh, yes.
You have a
Can you hear
camera?
me? Yes.
Yes, I can hear you.
So
Okay.
it's
What's your name?
Sarah Simmons.
Okay.
And we had spoke last week and you advised me that I would need legal counsel to proceed further.
Yes, ma'am.
And so
Go ahead.
I have reached out to Danielle Kramer's office with Sweeney is who has represented Cold Scoops in the past. However, due to a situation between my previous partners kind of left me in this situation and him representing him, they're not able to represent me. I did call Fink's office this afternoon and make them aware of the conditions in which I'm trying to move forward.
Got it. Okay,
I do have legal representation today.
Okay, I get it now. So there was a partnership of some type. The attorney you thought you would get is representing the partner. You're there by yourself and they declined it because of what may be a conflict.
Right. Correct.
Okay. How much is monthly rent?
$4,425 currently.
Say that amount again, ma'am.
$4,525 and a few odd cents, and that changes July 1st.
Okay. Goes up or down?
I believe it increases by, I want to say somewhere around $31.
Okay, all right, okay. I'm not gonna worry about 31 with the numbers we're dealing with. So let me ask you this. And then I'll hear from plaintiff, but if I give you an adjournment for you to get an attorney, can you get the 4525 into court escrow?
I can within 7 days. I had told Mr. Fink's office earlier today, my intentions actually were, given some circumstances, but July 1st to pay the 22,000 rearage, and June's in addition, and then begin payments for July. There's an agreement that I'm just trying to get legal advisement to help me portray to that.
Okay, I hear you, but here's what I'm trying to do. I'm trying to, I won't say buy you time, but you need to get an attorney to represent Cold Scoops. So I need Cold Scoops to put money into escrow If you get the
Okay.
money into escrow, then I'm gonna give you time to get an attorney, because I realize you probably ran into a situation you didn't expect
Correct.
regarding the attorney. Because you were so sure last time you were here, that wasn't gonna be an issue for you. So I remember that. Okay. Missing.
Your Honor, at this time, plaintiff, is requesting a judgment.
I know you are.
If Your Honor is going to adjourn this pending that payment, we would request that you would take a judgment under advisement, and then if the payment is not in by midweek next week, say Wednesday, then we would submit the judgment, but otherwise.
Well, what she's indicating is that she'd be able to have it to the court by the 7th. Is that right, ma'am?
Yes.
Okay, so that's that Friday.
And then I suppose we'll be in-
Here's the way I view it. And that is, if I set this for the 14th, require her to pay that on the 7th. What I will tell plaintiff, if that's not paid, you're going to get your judgment on the 14th. We're still going to be in that month and whatever. But I want to be fair to make sure that the defendant's represented and the like. So that's what I think I'm going to do. I understand what the plaintiff wants, but I'm going to decline to do that at this point. So, ma'am, I'm going to adjourn this to June 14th, 2024 at 3 p.m. Okay. You're to pay $4,525 into court escrow. You're to do that by the 7th.
Okay.
Okay. And then you're also to get yourself an attorney so that Cold Scoops can be represented in this. Okay.
Okay.
And I'd suggest that if you get your attorney, have them reach out to plaintiffs, see if you guys can get this resolved. All righty?
Okay. Thank you.
All right. Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. You need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in first. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.